Good morning, everyone. I hope everyone's doing well this morning.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor.
Yes, good morning.
Morning. Hello.
Hi. I'm sorry, say it again.
Natutu.
Um,
So you can.
we have the
All right. Taka Panther.
do we have the PDs in the courtroom?
We only have Ms. Vigiletti here, Your Honor.
Okay. Are we ready with any of Ms. Vigiletti's cases?
Which one you ready with?
Yes.
She's still interviewing one of her clients. Can we
Okay. You all just let me know when you're ready.
all right.
Hold on.
Hold on.
Hold on.
Hold on.
Miss April.
Miss April.
Yes, ma'am.
Yes, ma'am.
Is Jerica
Is
Combs on the calendar?
Is who?
Jerica Combs.
Yes.
No, not you. I'm sorry, Miss Jerica Combs.
I don't think they need her.
Okay. I have Miss Curry here. Come on.
Officer Milton, we're waiting for the PDs to join us. So we don't have any of the PDs on with us right now. So if
I
we can,
understand, Your Honor, but I was just making sure to see if Jerica Combs is on the court calendar for SAP.
okay.
Officer Milton, she's on the competency calendar.
Okay. I'll bring her back if she's needed.
Okay, thank you.
What conference are you going?
Huh?
What
Mhm.
Bye, bon. Bye.
Good morning, Your Honor. We're ready to start with position number 16, and this is going to be Mr. Mario Lewis.
Good morning, thank you.
Good morning.
Good morning, good morning, Ms. Vigilante. Is this a negotiated plea?
Yes, sir.
Okay, good morning, Mr. Lewis. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
How you doing?
I'm doing well, thank you, Mr. Lewis. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, thank you. Good morning, Mr. Graham.
Good morning, Your Honor. This incident took place on December 27th. The officer observed Mr. Lewis taking some items off of the shelf at the Walgreens. The state is recommending 12 months, served 30 days, credit for time served 16 days. The balance probated, $500 fine, an anti-theft course, 40 hours community service. Stay away from the Walgreens store 16088, which is located at 205 Peachtree Street Southeast. And for count 2, 12 months probation concurrent with count 1. We will ask the defense to stipulate to factual basis, venue, and identification.
We do.
Anything further, Ms. Vigilante?
Yes, Judge. We were wondering if it is possible, once Mr. Lewis completes his anti-theft course, his community service, and pays his fine, if his probation could be converted to non-reporting.
Okay. Mr. Lewis, it's my understanding that in case 23 CR 008422E, you wish to plead guilty to theft by shoplifting and obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
I do.
Has anyone forced or coerced you to plead guilty?
Sir.
Okay, I'll accept the plea as negotiated, Mr. Lewis. Let me see, as soon as you finish the 40 hours of community service, the anti-theft class, and pay the $500 fine, I'm going to have the probation terminate. So the sooner you get it done, the sooner you're not going to be on probation, okay? So get it done in the first couple of months and then you're done.
All right.
But just stay away from that Walgreens store, okay?
Yes, sir.
All right, good luck to you, Mr. Lewis.
All right, good day.
Thank you.
Next, Your Honor, we have position 17 and 18. And this is going to be Mr. Ronald Lewis.
Okay, thank you. Ms. Vigilante, what are we doing with Mr. Lewis this morning?
Yes, Judge, we'd like to discuss the possibility of a non-negotiated plea.
Okay, what is it? The jail time that's at issue?
I'm sorry, just 1 second.
Woods.
We were wondering if it is possible, the state has requested SDET, and Mr. Lewis was wondering if it's possible to convert that to community service. Although he has been in trouble before, it has never been for a crime of any sexual nature. This was a misunderstanding and it never happened again. And he's concerned about the cost of the class. He is working at Urban Link, and he's confirmed he can go back to that, but he does.
Hold on, Ms. Vigilante. I'll let you give your whole presentation. I just wanted to know before I got into it what the issue was between you and between you and the state. So let me hear about the facts. Mr. Lewis, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning. Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can place your hand down. Thank you. Mr. Graham?
Thank you, Your Honor. This incident took place on January 17th of 2020. Law enforcement responded to the location at 1895 Plaza Lane Southwest, apartment 334 in Atlanta, in regards to a sexual crime. Upon arrival, the officer spoke with Miss Kiana Johnson. Her first name is Kionna. She was sleeping over at a friend's house when Mr. Lewis was also sleeping there. She states he was sleeping on the couch behind her. He got off the couch, walked over to where she was sleeping, and pulled her pants down. Mr. Lewis then started to fondle her rear end and near her vagina. She woke up, asked Mr. Lewis what he was doing, at which point Mr. Lewis got off of the floor, walked back to the couch, and started laughing. Miss Johnson then jumped up, told Mr. Lewis that she was going to call the police. Mr. Lewis then ran out of the door. He was out on the scene when the officer arrived. The friend who owned the apartment was on scene, but did not see or hear anything as she was in the bedroom asleep. So the state is recommending 12-month, serve 120 days, credit for time served 32 days, balance prorated. The SDET is an evaluation, and if treatment is recommended, if there's nothing to recommend, then there's nothing for him to do. No further contact with Ms. Kiana Johnson. And this recommendation is based on the overall nature of his history.
Thank you, Mr. Graham. Ms. Vigiletti?
Yes, Judge. Like I said, this incident was a bit of a misunderstanding, but Mr. Lewis understands and accepts responsibility for what happened, has had absolutely no contact with Ms. Johnson since and does not intend to. He is a caretaker for his elderly uncle whom he lives with. He also has a 9-year-old girl, so he's just concerned about the cost that often comes along with SDET evaluation and treatment, and has asked and is more than willing to do community service instead, if possible.
And Your Honor, I'm sorry to interrupt, but we would like to sound for the victim in accordance to Marcy's law.
Okay. If Ms. Kiana Johnson is present and wishes to address the court, now is your opportunity to do so. Ms. Vigiletti, I am often happy to convert fines into community service to help people out that way. This is not a fine. I believe that given the circumstances of what he wishes to plead to, that it's acceptable that he have a SDET an evaluation. So I would order that. So if you want to discuss that with your client before we move forward, I'm happy to give you that opportunity. But if you want to take a plea, it's going to include the SDET.
Understood, Judge. We did discuss, and Mr. Lewis will take the plea.
Okay. Nothing further, Mr. Lewis. It's my understanding that in case 20 CR 004098Y, you wish to plead guilty to one misdemeanor offense. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. It's
Sorry,
my understanding that position 18 is going to be null pros. Is that correct, Mr. Graham?
Yes, sir. And
Okay.
we would like for the defense to stipulate to factual basis venue identification for purposes of the plea.
We do stipulate for the purposes of the plea.
Good luck to you, Mr. Lewis.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome, sir.
Next, Your Honor, we're going to go to position number 23. That's going to be Mr. Kevin Woods.
What are we doing with Mr. Woods this morning?
Yes, Judge, we would like to discuss the possibility of a non-negotiated plea in this case as well.
And what would not be negotiated?
The 12 months probation requirement, just because Mr. Woods does not live in the state of Georgia.
Okay. Well, I would have it go, I don't know what the facts are, but non-reporting, he's gonna have to, if he's going to accept the 40 hours of community service, he's at least gonna have to be on probation until he gets through that. But if there's no objection from the state, I'll have it go to a non-reporting once he completes.
And Judge, once he completes, he lives in Florida, he has a home and job set up in Florida. He can leave the state and live there on non-reporting probation?
Yes, I don't see why not.
Okay, well then that was our only question today, so prepared to take the plea.
Okay. Yes, good morning, Mr. Woods. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me, sir? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? You swear to tell the truth, Mr. Woods? Is that a yes? Does he understand my question? Ms.
Yeah,
Vigilante?
just speak up a little.
Yeah.
The mic is down.
Oh,
Yeah, Judge.
okay, thank you. I'm sorry, Mr. Woods. I just couldn't hear you. Yes, Mr. Graham.
Thank you, Your Honor. This incident took place December 29th of 2023. Officers are dispatched to 131 Centennial Park Drive. Mr. Woods was setting fires in trash cans and around the stairwell. The state is recommending 12 months, served 28 days, credit for time served 14 days, balance probated, 40 hours of community service, stay away from 131 Centennial Olympic Park Drive. And on count 2, 12 months probation concurrent with count 1. And we would like the defense to stipulate to factual basis identification venue for purposes of the plea.
We do stipulate.
Who you want to?
Anything further, Ms. Vigilante?
No, sir.
At the time, was he residentially challenged?
Yes, Judge.
Okay.
What happened, Mr. Woods came to stay with his grandfather in Georgia, but was very surprised to find that he could not locate his grandfather when he got to Georgia. So he was temporarily homeless as he was setting up his residence and job, which he has secured in Florida. And actually the very next morning was planning on going to Florida. So he found himself very temporarily homeless, but has already found himself a stable income and stable living situation for the future. So this won't happen.
Okay. Mr. Woods, it's my understanding that in case 23 CR 008462J, you wish to plead guilty to reckless conduct and criminal trespass. Is that correct?
Correct.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Right.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Correct.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'm going to accept the pleas, Mr. Woods. I'm not going to accept the recommendation. It's going to be 12 months to serve, 28 days, credit for time served, 14 days, ballot suspended, and stay away from Centennial Olympic Park. Criminal trespasses will be the same. So I'm giving you a fresh start so that you can get on back home to Florida, okay? All right. Good luck to you, Mr. Woods.
Thank you, sir. Next, we're gonna go to position number 20, Mr. Matthew Reed.
Okay. What are we doing with Mr. Reed this morning?
I'm so sorry. I'm just getting new information right now.
Okay, let me know when you're ready, Ms. Vigilante.
We're ready, Judge. This will be a negotiated plea.
Okay, good morning, Mr. Reed. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you. Mr. Graham?
Thank you, Your Honor. This incident took place on August 5th of 2022 at the Walmart located at 970 Mansell Road, Mansell Road in Roswell. The defendant was monitored via security cameras and noticed to have taken some merchandise. The state is recommending 12-month, served 22 days, credit for time served 11 days, balance probated, anti-theft course, 40 hours of community service, and stay away from Walmart at 970 Mansell Road in Roswell, Georgia. And we'd like the defense to stipulate to factual basis venue identification for the purposes of the plea.
We do stipulate.
Anything further, Ms. Vigilante?
No, Judge. Nothing further. Mr. Reed would like to take the negotiated plea.
Okay, Mr. Reed, it's my understanding that in case 24 CR 000088D, you wish to plead guilty to theft by shoplifting. Is that correct? Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with her representation? You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Mr. Reed, when you complete the terms of the probation, I'm going to have it terminate. So the sooner you get it done, the sooner you're not going to be on probation, okay?
That's fine, sir.
All right, good luck to you, Mr. Reed.
Mike. Next, Your Honor, we're gonna go to position 6 and position 7. And this is gonna be Dante Buford.
Okay, thank you. Good morning, Mr. McLean. This is going to be a plea this morning.
It is, Your Honor, 2 different pleas. Thank you.
Okay, good morning, Mr. Buford. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, sir.
Good morning. Yes, thank you. Can you raise your right hand for me?
Sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can place your hand down. Yes, Ms. Falk.
Yes, Your Honor. As to position 6, the attempting to misrepresent tag is 12 months concurrent with count 2 with a $135 fine. On count 2, the fleeing and eluding, the recommendation is 12 months, serve 30 days. Credit for time served 15 days. That's going to be from December 28th of 2023. Balance suspended and a $1,000 fine. On count 3, and we're going to strike the Operation 21. On count 3, you're recommending 12 months concurrent to count 2, a $265 fine. That's the improper erratic lane change. And on count 4, the suspended license, 12 months to run concurrent with count 2, balance probated. That would be a $500 fine and 6 months suspension, which is statutory. On position 7, The simple battery, the state's recommendation is time served. The defendant spent 287 days in jail from January 29th of 2022 to November 11th of 2022. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
Ms. McLean?
I'm sorry. Okay. Your Honor,
Just a stipulation, Mr. McLean.
yes, we do so stipulate to the facts, the factual basis, the venue, and the.
Anything further, Mr. McLean?
No, Your Honor, we just asked the court to accept the negotiated plea.
Okay, Mr. Buford, it's my understanding that in case 23 CR 0084443G, you wish to plead guilty to attempting to misrepresent a tag, fleeing or attempting to elude a police officer, improper erratic lane change, driving while license suspended or revoked. And in case 22 CR 0051255G, you wish to plead guilty to simple battery. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Buford. Let's see. When you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get the terms done, the sooner you won't be on reporting probation, okay?
Thanks so much, Your Honor.
You're welcome. Good luck to you, Mr. Buford.
All right, so good to meet you. All right, too. Score.
We have position number 2 on the add-on calendar.
Just know two on that on.
I have, this is position 2. Regina Curry, is that right?
Yes, Judge, good morning.
Good morning, Ms. Abden. What are we doing with Ms. Curry today?
Not guilty, waiver of arraignment, and need to be heard on bond.
Let's see, what's the current bond and what are the facts?
Current bond, Your Honor, is $1,000. That is going to be $500 per count. As for the facts of this case, this incident happened back on, and sorry, I'm just looking at her history. The incident happened around December 17th of 2023. On that date, and the defendant was later arrested. On that date, what occurred was that the defendant had gone to the MARTA station at 5 Points, threw a metal barricade onto the southbound train tracks, which caused significant rail delays. And that was in violation of a permanent MARTA suspension. The officer also observed the CCTV footage, which showed her throwing a metal barricade from the concourse level to the southbound trackway, where it made contact with the electrified trackway. Multiple patrons were seen on the southbound platform where the incident happened, and the defendant was arrested and was in violation of a permanent MARTA suspension that had been issued in February of 2023. Looking at the defendant's history, her history is essentially littered with cases of this nature. She has 30 cycles at this point. And just going to her most recent ones, she was most recently convicted of criminal trespass in 2023, and has a number of criminal trespasses. If you go to her, you look in case manager, you'll see that there was a criminal trespass August 16th of 2023, February 27th of 2023, February 1st of 2023, July 18th of 2022. So those were her most recent, and the most recent one also included, the criminal trespass also included a PI. And so for those reasons, I believe that's why the bond was entered in the way it was, a $500 bond on each count. And I'm not sure if there has been any sort of social worker visit or any kind of conversation with Ms. Curry about kind of where she is and her status. I know her most recent conviction, which she's still under probation on, she was ordered to stay away from all MARTA properties, and that was on September 7th of 2023. She violated about 3 months later. So that's why the state asked for a surety bond on this case, and that's why we're asking for it to remain as set. That's all for the state.
Thank you, Ms. Abden.
Yes, Judge. So both of our social workers actually saw Miss Curry. I also visited with her. It's the opinion of the social workers. This is not a competency issue, and MH is not something that needs to be addressed as it relates to this case. I would like to be heard on bond, Judge, because she has been in jail for 16 days now. She does have a Georgia address. It's in the area. She lives with a friend. She's lived there for the past 2 years. She also provided me with an email address. And we will be representing her moving forward. So she does understand her obligation to return to court. She's not a flight risk. She did graduate from high school. She has 3 kids, Judge, and she does want to return and they're minors and be with those children. The reason she's still in jail is due to her indigency. So I'm asking Your Honor to take that into consideration. I do understand there are several prior criminal trespasses. However, I spoke with her and she's not going to return to MARTA. She's willing to comply with whatever restrictions. She's just trying to get home. And I'm asking Your Honor to consider that and set bond at a signature bond to allow her to get out.
And Your Honor, I will just say, I mean, I'm not doubting PD Abden at all, but something seems to be going on here. The last 4 convictions she's had in the last year all are from MARTA. So I don't know why, and I don't know what's going on, but something keeps going on that she keeps going back in violation of probation order after probation order after probation order. I've looked at the last 4 cases since 2022. Every single one involved MARTA. Every single one tell her to stay away, and every single time she gets rearrested. So I'm not sure what's happening here.
And Judge, I can speak to you know what happened with the social workers, but if we could just do it, I guess, offline. I don't want to discuss MH issues in this forum.
Okay. I think the concern, Ms. Abden, is that, and I don't want to keep her sitting in jail on this type of a charge when she could not be in custody, especially with the recommendation. But there does appear to be something going on, and I don't want her to get in further trouble by continuing to go back, even if I give her a signature bond. So I just want to know that you've spoken with her, the social workers have spoken with her, and that whatever the problem is, that you've been very strong in transmitting to her that she cannot go back to MARTA, regardless of what the reason is, whether she's trying to get to work, whether they don't want her there and she's going to get arrested again if she goes back. But I just don't want to place her into a situation where she's going to get herself into more trouble without some type of assistance. I think that what you're telling the court is that you are trying to provide her with assistance through the social worker, that you've done that. Is that what you're telling me?
Correct. Like I said, she's met with them, 2 separate social workers, 2 separate visits. I also met with her. It's my understanding that she will not return, and she does understand she cannot return to that location.
Okay. I don't want, I am going to convert the good bonds to signature bonds through pretrial level 1. Stay away from all MARTA or abide by any active MARTA suspensions. And no drugs, alcohol, or weapons while out on bond.
Thank you.
So, Ms. Curry, I'm going to give you one final opportunity. If you go back to MARTA, you won't get this opportunity next time. You understand?
Yes, sir.
Okay, good luck to you, ma'am.
Thank you.
Thank you.
Who do we have next?
ACDC, who we have next?
Position number. Position number 1, Jasmine. Bennett Jasmine.
Bennett's the waiver. That's
She waived her appearance.
right. On Bennett, we're waiving presence and arraignment. I'll file that.
Okay. Who else do we have?
Let's see, there was a Mr. Hightower. Did we have the thing yet?
As soon as I have a pause, I'll give them a call back. I tried calling earlier and got no response.
Okay, super.
Okay, we have position number 2, Bernard Christie.
I think the state is looking, well, I think we had finished our conversation on Christie, had we not?
We had.
Okay, Christie is a not guilty and a bond request, Your Honor. That's Ms. Bernard.
Okay.
I'm sorry, we're calling her by first name.
Do I need to arraign her? Mr.
No, Your Honor, we'll waive the arraignment, but we do just need to ask for a bond.
Okay, so you're filing a written waiver for Ms. Bernard. So may I have the facts and the current bond?
Yes, Your Honor. Can I also make the request if pretrial is on the line, if they can see what her criminal history is?
Okay, good morning, Ms. Tyson.
Good morning. So for Ms. Bernard, I only have 2 arrest cycles. First one is in 2020. Let's see. And it appears that's the same case that's on the calendar, and her last arrest was December 27, 2023, and that's for the
Failure to
FTA that's
appear.
on the the FTA that's on the calendar also. I don't have anything else.
Okay, I just wanted to double check what we had. So this incident happened, Your Honor, back in 2020. I believe it was June 16th of 2020. Officers responded out to 3459 Buckhead Loop, which is the Spring Hill Suites. They were advised that the defendant was refusing to leave the room. After speaking to her, she agreed to leave, was trespassed by the staff, including Mr. Capria, who is the manager of Spring Hill Suites. A return call, the officers had to come back out to the property because she came back onto the property and would refuse to leave. At that point, she also damaged the lock sliding glass entrance doors, and the damage could be seen by the officers. The defendant was then arrested. Once at the Fulton County Jail, the defendant struck Officer Moss in the face, knocking off his glasses while he was being detained. It does say that she was sent to Grady for toxic evaluation, so I believe maybe there were some ADET issues involved. Least, yeah. So the state's issue here is that it has now been approximately 3.5 years since this incident happened, and the defendant is now back in custody, and really no explanation as to what happened during those ensuing 3.5 years where she was not responding to the court and not coming to court. And so for that reason, we do ask that this case be reset onto the court calendar that she failed to appear on. That would have been, let me just pull that up, courtroom C, which is Judge Dixon's courtroom. A bench warrant was issued, it looks like on November 22nd of 2021. And there also looks like a dormant case warrant issued December 14th of 2022. There's actually 2 entries in the system. But I would ask that it be returned to Judge Dixon to address this case, since it has been over 3.5 years since she appeared.
Mr. McLean.
The state and the defense are in agreement that it should go to trial. Your Honor, she does disagree with the facts as stated by the state. She
was not aware that you should change your address at the clerk's office as opposed to simply forwarding your mail. So that's why she missed out on the knowledge of the court date. When she came to see about this, she was arrested in Banks County, which I believe that's county seat is Homer. I guess she was on I-85 coming south to Atlanta. So the arrest is on this FDA. Your Honor, because she lives in New York now, if she doesn't get a signature bond, there's nothing she can do about bond because she has no Georgia person with a Georgia residence to go to a bonding company and sign any papers with her. So she's asking the court to consider a signature bond. She works at a company in which she does, let's see, she's not a CPA, but she works in an accounting division of a type of financial company where she processes accounts payable. And Your Honor, this is her only case and size the heck out of that.
Okay, my normal practice is if a division judge issues a bond and that their court dates are missed, that I return it to them to decide whether they're going to modify that bond. That's what I do in most cases. That's what I'm going to do in this case. I'm going to return the case to Judge Dixon to modify the bond if she so sees fit. All right, good luck to you, Ms. Bernard.
Ms. Bernard, also, there was a alternate path you were thinking of overnight in case the signature bond was not granted. What was did you have any communication to me on that?
To plead guilty?
Yes. Did you wish to switch over?
Yes, please. Yes.
Okay. Your Honor, I told her, because the New York thing, and we discussed everything pretty fully. So she would like to plead guilty at this point.
Okay. I guess Ms. Falk, anything further?
Yes, Your Honor, the state's recommendation on this was 12 months probation, serve 36 days, credit for time served 18 days. That's going to be from June 16th to June 17th of 2020 and December 27th of 2023 to today. We were also asking the balance, and based on this, will be agreeable to the balance being suspended, but we would still like that she do the 8 weeks anger management. So we're agreeable with balance being suspended after the 8 weeks anger management is completed. Stay away from the Spring Hill Suites at 3459 Buckhead Loop Northeast. No alcohol, drugs, or weapons on count 2 and 3. We are agreeable, on count 2 and 3, yes, we're agreeable with those merging with count 1. And count 4, that's going to be 12 months probation concurrent with count 1, balance probated or balance suspended upon completion of her 8 weeks anger management, and stay away from that Spring Hill Suites.
Okay, is that the understanding, Mr. McLean?
Certainly is.
And we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
We do.
Okay, given that I have not addressed Ms. Bernard as of yet, good morning, Ms. Bernard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Thank you, Ms. Bernard. You have been charged in case 20 CR 003747C with simple battery and criminal trespass and damage to property. It's my understanding that you wish to plead guilty to those charges. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Ms. Bernard. As soon as you complete the terms of the probation will terminate. So the sooner you get it done, the sooner you won't be on probation, and the sooner that you can get on with your life, okay?
Yes, Your Honor.
All right, good luck to you, Ms. Bernard. It's my understanding that position number 3 is going to be non-class. Is that correct, Ms. Falk?
That is correct, Your Honor. We're handling that now.
Okay, very good. All right, good luck to you, Ms. Bernard.
Thank you.
Position number 22 and positions add-on 5, Gregory Vaughn.
Oh, that's Gregory Gore. Your Honor, there's,
No, there's a Gregory Vaughn and there's a Gregory.
oh, I'm sorry, you're right. On Gregory Vaughn, that's a not guilty, and he's going to try to make his bond. Is he in the courtroom? Okay, he's on the screen. Mr. Vaughn was going to ask the court to consider lowering his bond that would help his family finance.
Okay.
I can't.
Gore has to mute.
There we go.
Now you can talk.
Okay, if I might turn to that, let's see.
So it's just so I know, did he miss a court date for a division judge?
I believe so, Your Honor. Hold on just a moment. If you can give me a moment to get to the add-on calendar, because he is on both calendars. So we are showing. Actually, yes. So he had an FTA. And let me just pull up his, and it's from his 19 CR case, which is on the add-on calendar. So it looks to be that he failed to appear. Let me see. In Judge Porter's courtroom on August 6th of 2022, November 9th of 2022. So there were two different failure to appears that resulted in the warrant being issued. It looks like the first warrant was issued on August 16th of 2022. And so that is the basis for him coming here today. We do ask that this case be put on Judge Porter's calendar on the 19 CR case to address those charges and to address that outstanding bench warrant. It's in the amount of $1,000. He is also in court today because of a $2,500 surety bond on a battery, family violence, cruelty to children that occurred where Your Honor set the bond on December 30th of 2023.
And that's correct, Your Honor. My request is a little nuanced compared to some of the requests in that I don't have an argument to counter the fact that there's a $1,000 bond on the FTA, which is line 1 of his booking sheet. But lines 2 and 3 are that $2,500 bond that Your Honor just set, and we're just simply asking the court to consider cutting that in half. The family is going to try to make the bond.
Okay, let me get to position number 22, the battery, family violence, and the cruelty to children. So what you're saying is that I set this bond, and this bond is in what amount?
$2,500.
Yes, Your Honor.
It's $2,000 on the battery, family violence, and $500 on the CC 3 degree.
Okay, and so was the failure, and this was, when did I set the bond?
Just a few days back, about
December 30th, Your Honor.
Okay, so you're not asking me to do anything as far as a failure to appear on position 5 on the add-on calendar. What you're asking me to do is lower the bond for the battery and the cruelty. Is that what you're asking us to? Okay.
Right, Your Honor. I figure you feel more discretion there because that was yours.
Right, I understand. And what are you asking me to lower it to?
If you could cut it in half, that would simply help the family. It still would be a substantial total bond that he would make and be able to, under the burden of that total bond, that's quite an incentive to not mess up for a failure to appear again.
Okay, so you're asking, go ahead, Ms. Vaughn.
Oh, no. I'm sorry, Your Honor. I didn't mean to interrupt. I was just, once you're completed, I do just want to put the facts on the record to refresh Your Honor's recollection as to maybe why you gave that bond.
Okay, Go ahead and do that now for me then.
So this incident happened on December 29th, 2023, at 615 Oliver Street. Officers stated, spoke with Miss Jalea Martin. She stated that the defendant, her child's father, became upset with her because she went to the store with a friend. He then strangled her by wrapping his hands around her neck and punched her in the mouth with a closed fist. Their daughter was in her hands at the time that this happened. Officers did observe that Miss Martin had bruises on the right side of her neck, a swollen and busted lip, and they did take him under arrest for battery family violence. That's in addition to the 2000, and this was with a different victim, the 2019 simple battery charge that he FTA'd on. That involved Miss Tashana Lovett, who was living with him at the time, where he hit her in the head with his hand. And so this is the second charge for family violence. And as you can see, the violence is escalating, as the first charge involved just striking, and now this charge involves possible strangulation.
And was there a possibility that you all were going to seek to elevate these charges?
Let me just look at our notes briefly on that. See if there's any notes from SEA as far as what we indicated. There is not. So I'm not sure what our intentions were on that. I obviously can refer that up to the DA's office. We don't have a strangulation assessment at this time, which kind of makes it difficult when we're trying to elevate a strangulation case.
Okay, it was my, if I'm remembering correctly, and I may or may not be, it's my thought, I believe, that whoever was handling this initially let me know that there was a possible transfer. But if you tell me that there wasn't, or that there isn't going to be, okay, thank you, Ms. Falk.
And Your Honor, I'm not saying there isn't going to be. I'm saying without a strangulation assessment, we can't make that determination. And we would like to sound from Ms. Martin, Jalea Martin. We were not able to, I think the issue was we weren't able to contact her at the time when we went to SEA to make the determination whether this could be upgraded.
Okay, and are there any indications in your notes that someone has tried to contact her since SEA?
We're showing the last attempt was December 30th. I think that may have been kind of, I think I may have played a part in that, because we initially said we wanted to reset this case, but then discovered on the add-on calendar, they had actually added on the case that we were trying to reset to get both put on the calendar together.
Okay.
I think it caused a little bit of confusion on our victim advocate side, as far as I think they thought the case had been reset because I stated that and then received the add-on calendar subsequent to my request.
Okay, thank you. Mr. McLean, anything further?
Nothing further, Your Honor. Thank you.
All right, so for the $2,000 battery charge, I will lower that from $2,000 to $1,000. For the cruelty, it's $500. I'll lower that to $250. So it'll be a total $1,250 good bond, with all the other conditions that I imposed on my initial bond, Mr. McLean.
Yes, Your Honor.
All right, let's see. Good luck to you, Mr. Bond.
Okay, we have position
He
number,
wants you to call him, Mr. McLean. I think that's what he's saying. So if you can give him
I'll
a
do
call
that.
after report. Okay,
I'll be in communication with him. Yes.
thank you. Say it again for me.
position number 19, Nutting.
Okay, thank you.
My understanding is that was transferred.
Have you been in contact with the DA in this matter?
We
For the
have, Your
possible
Honor, we're
change.
still waiting for a response. I did send an email and then a follow-up email to get the DA's office determination. I have not received a response at this time.
Okay. So let's see, what's the request? What are we doing with Miss Nutting today?
I apologize, Judge. It was my understanding that we wouldn't be doing anything with Ms. Nutting today because we were waiting on that response.
Okay, so we should reset her for another SAP calendar next week.
If we can reset it 1 week, Your Honor, I believe by then I should be able to get an answer one way or the other. It's a fairly straightforward request, so I just need to follow up again.
Okay, 7, so that's the 18th, is that right?
Yes, Your Honor.
Okay, so Ms. Nutting, we're gonna reset your case until next Thursday, so someone will see you back next Thursday, ma'am. 1:18.
Next, Your Honor, we're gonna go to position 8 and position 9, Mr. Gregory Gore.
Your Honor, Mr. Gore, there's one thing I need to look up on Odyssey before I'm ready. It's just one particular fact I need to look up, and I'll do that in just a moment over here on the other desk.
Okay, so you want me to hold, or what?
Yes,
What do you
yes,
want me to
Your
do,
Honor.
Mr. Plum?
We could hold on Mr. Gore.
Okay, so we'll be back to you, Mr. Gore.
Your Honor, so can we go to the probation revocation calendar?
Okay, wherever you want to take me, I'm fine.
I'm gonna go to position 3 and 4, Mr. Christopher James.
Okay,
Good job.
You got that?
Yes, sir.
Okay.
yes, good morning, Mr. James. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning, sir. Yes, good morning also, Officer Allison. What's
Good
going on
morning.
with Mr. James?
Mr. James owed probation supervision fees in a total of $120, victim crime funds in a total of $27, failed to report on September 12th, 2023, September 19th, 2023, and October 9th, 2023, failed to complete anger management. He has 92 days remaining on this case. Probation is recommended to continue on probation and complete the anger management within 60 days.
Yes, Ms. Vigilante.
Yes, Judge, I spoke to Mr. James yesterday at length. It was a pleasure to speak to Mr. James. He was explaining to me that, as I'm sure the court is aware, based on the underlying offenses, he has been struggling with addiction, and he stopped reporting when he was evicted from his home last year. That was a bit of a turning point for him, and he actually found a great recovery program where he is living. My brother's keeper in Riverdale, which is a program of Arbor House Healing. He is nearly 3 months sober, living in this great structured community. He understands, he was confused about the fees because when he was sentenced before, 2 months of the fees were waived. He thought all of the probation fees were waived, so he didn't understand the fees for probation. But he understands his reporting requirements. He won't be moving again, so he'll be getting his mail. He's on a great path and is ready to complete this probation. My concern is that Mr. James is on disability income, so he only earns $843 a month. We have found an affordable anger management program for him to complete, but he does owe $147 in back fees, and then we'll continue to owe $49 a month in fees going forward. And he does pay his own rent, pay his own phone bill, his own food, all of his own expenses in the sober living community. And so I was just wondering if there's anything we could do to help him out, just because disability is such a fixed income at such a low rate. If there's anything we can do just to help him out with the financial piece of this probation, because I'm very confident he'll be successful.
How much anger management does he have to do?
6 weeks.
6 weeks.
All right, so Mr. James, I understand that you've been going through some challenges.
Yes,
And I
sir.
understand that you've made your way through those challenges. You wouldn't be sitting here, and the last thing that somebody wants to be is incarcerated. You wouldn't be sitting here if during that point in time you've just communicated with probation to let them know that you were going through challenges. They would document that and report that to me. But if you just go missing, then you know that there's going to be a warrant out for you, and you know that ultimately you're going to be sitting where you're sitting today. So I would encourage you that if you're ever in the situation, get in touch with somebody, let them know where you are, because you know it's gonna eventually catch up with you. I want you to get this behind you, so I'm going to give you some incentive to get this behind you in the next 2 months. I'm going to reinstate you, allow you to do the 6 weeks of anger management. I'm not going to do anything about what you owe presently, but as an incentive, I'm going to waive the next 2 months of probation fees. That will give you enough time, or should give you enough time to get through your probation. And once you complete that 8 weeks of, or that 6 weeks of anger management, I'm going to have the probation terminate. Okay, so as soon as you get it done, the sooner it's going to terminate, and the sooner you're not going to have to be on probation. Okay. But you're welcome. But if you come back and you haven't done it, you know they're going to ask me to. They're going to ask me to revoke these, or whatever amount of time you have left, and you're going to be right back where you are. So I don't want to see that happen, okay? All right.
Thank you, Judge.
Good luck. Good luck to you, Mr. James.
We have position number 7 and 8 on the probation revocation calendar.
That's Mr. Norris?
Yes.
Oh, that's, okay, yes, again, Mr. Norris, good morning. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay. Let's see, who is representing Mr. Norris?
Norris is I'll do that, Your Honor.
Okay, yes, Officer Allison.
Mr. Norris owes court fines and surcharges in total of $687.50. Probation supervision fees in a total $120. Victim crime funds in total $27. Failed to report as directed on April 18th, 2023, April 24th, 2023, May 5th, 2023, and May 22nd, 2023. He has 211 days remaining on this case. Probation is recommended for time served. Case closed.
How much time has been served?
He has did, as of today, I have 16 days, if I did my math right.
Okay. Any objection, Mr. McLean?
I don't think he'll have any objection, Your Honor. Let's double check.
Okay, well, time served. Good luck to you, Mr. Norris.
Thank you, Your Honor.
You're welcome.
Your Honor, we're gonna go to Mr. Paul Smith, and he's position 9 and 10 on the probation calendar.
Okay.
Oh, Your Honor, if I may interject an announcement.
Well, give me a sec. I have Paul Smith. Is that who we're?
Yes, Judge. He's right beside me.
Okay, I just wanted to make sure. And Mr. McLean, what's your announcement?
On the position with Gregory Gore, he has signed a waiver of presence and arraignment. And I've signed it with him.
Okay, so position 8 and 9 will be returned to the division judge, and he'll get notification of his next hearing date.
Thank you, Your Honor.
Okay, good. Mr. Smith, good morning. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Let's see, Officer Allison.
Mr. Smith owes probation supervision fees in total $200. Victim crime funds in total $45. Failed to report as directed on September 25th, 2023, October 27th, 2023, and November 12th, 2023. Failed to complete 10 hours of community service. He has 110 days remaining on this case. Probation is recommended for a time served. Case closed.
How much time was served?
14 days.
Any objection, Ms. Abden?
No objection, Judge. We're just asking that you take the state's recommendation. The probation statement.
All right, Mr. Smith, time served. Good luck to you, sir.
Thank you.
We have position number 4 on the SAP calendar.
Okay. Position 4, I have that position 4 was released.
Matt,
Braithwaite, I believe, was released. Well, my calendar,
ACDC, who do we have? What's the name?
give me a second.
Well, she can just tell me her name if you want me to.
Matthews.
Okay, good morning, Ms. Matthews.
Good morning.
She's on the add-on, Your Honor.
Okay,
I have the other message. I'm ready to do.
Position 4 on the add-on.
okay, thank you. Let's see, what are we doing with Ms. Matthews this morning?
Morning, Judge. Ms. Matthews would like to plead not guilty. She did waive her arraignment, but wanted to be present today.
Okay, so written waiver will be filed, is that correct?
Yeah, so I did submit a waiver.
Okay, so good morning, Ms. Matthews. Your case will be returned to the division judge and you'll get notification of your next hearing date, ma'am.
Okay.
All right, good luck to you, Ms. Matthews.
Thank you, Judge.
We have position number 10, Hightower.
Your Honor, if you could give me about 5 minutes, I just got off the phone on that case and I need to submit a recommendation to the defense. The DA's office did respond on that case and declined to upgrade it. And so I do need to submit a recommendation to Mr. McLean.
Okay, so Mr. McLean, I'll give you the opportunity. Are you with me, Mr. McLean?
yes, Your Honor.
Okay, did you hear what Ms. Falk said?
On whom?
Darrell
Okay.
Hightower.
Okay, the offer is in, so I'll check the chat.
No, I just got off the phone and just with the other agency that I was telling you about that I needed to call and am about to make a recommendation. I just need to go over one thing and I'll shoot it out in the chat. But if you guys
Very
give me about 5 minutes to do that.
Excellent.
Thank you.
Okay, and then I'll take it that you'll need to speak with Mr. Hightower in private to convey the offer. So, Mr. Hightower, once we get an offer in your case, Mr. McLean's going to call you and to speak with you about that. Okay.
Yes, sir.
All right. So we'll be back. We'll be back with you, Mr. Hightower.
Yes, sir. Next, Your Honor, on the probation revocation calendar, we have position 1 and position 2, Mr. Willington Hall.
Okay. Thank you. Yes, good morning, Mr. Hall. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
I do.
Thank you, sir. Officer Allison?
Mr. Hall would pay probation supervision fees in total $400, victim crime funds in the total of $90, failed to report as directed on September 14, 2023, September 28, 2023, and October 19, 2023, failed to complete a domestic violence intervention program. He has 69 days remaining on this case. Probation is recommending to revoke the balance.
Ms. Abden?
This is a reset from Tuesday. You may remember this case. You allowed us to have more time to provide proof that he did take some of those classes and to try to see if he would be able to complete it in time. I was able to speak with Dr. Park at New Approach. That is where my client was doing the family violence intervention class. It's my understanding that he did attend.
And ACDC, would you mind muting for us, please? Thank you. I'm sorry, Ms. Abden. Go ahead.
No worries, it's fine. So he attended, from 4 classes. It was May 11th, May 8th, May 25th, and, June 1st. And then he, had a couple of absences, which led to a discharge. And then he tried again to start, on July 24th, 2023. And then he had a couple absences and he was discharged again. I spoke with him about this, and I'm happy to send this to probation as well as the court. It's just from New Approach. So when I spoke with Dr. Park, he said that if participants do not sign on by a specific time, they may not get credit for being there. And so it is my understanding that given all this, he would not be able to complete the family violence intervention class. And I'm asking the court to consider to give him anger management in lieu of the family violence intervention program. I understand that he did have time to complete this. He did attempt, it seems like there was confusion regarding requirements for attendance. And I spoke with Dr. Park extensively yesterday, and it sounds like there are all these rules of, how you can get credit. And so it is a little bit complicated, and perhaps he was confused, but at least he was trying. And so I did speak with you about what was going on in his personal life a little bit, and his wife is actually on the line if you'd like to hear from her. She is the complaining witness on the underlying case. But and just to summarize, he has 2 young children. One of them is 9 years old. She was recently diagnosed with diabetes, led to a hospital stay on and off a month. And then during the end of that hospital stay, his mother-in-law actually had a stroke. So his wife had to quit her job. She's the only caretaker for the 2 children and now her mother. They've been going through a lot in their personal life, Judge. And so he is the only breadwinner, and she really needs him at home to help with the kids and their mother. And so I'm asking you to consider reinstating him and allowing him to complete some of these requirements, and rather than the class he was initially assigned to do, he would be willing to do anything the court thinks would be reasonable, and he can complete within the 69 days.
Okay, so he has 69 days left. There's not too much that he would be able to do. But I do want him, and I understand his circumstances. I appreciate that he has at least tried to do some of the FVIP. I will convert the rest of it into 4 weeks of anger management. So he is to enroll in anger management within 1 week of being released. Complete 4 weeks of anger management, report as directed. So I'm going to give you the opportunity, Mr. Hall, but if you don't report, or if you don't go ahead and start that anger management, you're going to be right back where you are, and whatever the balance is at that point in time, I'm going to revoke it. Okay, so I'm going to give you the opportunity to get out so you can get this behind you. I just don't want to see you back here. Okay.
Yes, sir.
All right. So that will be the order of the court. Good luck to you, Mr. Hall.
Thank you. Your Honor, can we go to position 15, Mr. Xavier Kelly? I believe he has private counsel.
Okay. Let's see.
And Your Honor, on Mr. Kelly's case, on Mr. Kelly's case, we went into the clerk's record and I could not find an entry of appearance from anyone. And that was this morning.
Oh, okay. Mr. Kelly, who do you believe your lawyer is?
Oh, he came. I forgot his name though. He came yesterday.
You saw him. You don't know the name?
I forgot his name. He told me, but I forgot it.
Okay. Did you tell him that you had a hearing today?
Yeah, he knows. He supposed to be here, so I don't know.
Okay, well, we don't have any record of him, so. And you don't have any, you don't have any contact information? I mean, it's not much we can do without a name or without some contact information. Say it again?
I got contact information on, I had my dad, I talked to my dad, and he was talking to him, then he came up here yesterday, and I was like,
Okay, has he been paid?
yeah.
Okay, so the only thing I can really do, Mr. Kelly, is that I can give him the opportunity to appear at another time. There doesn't appear that that you have anyone representing you here today, so without your counsel present, there's nothing that we can really do. I can reset you till next Tuesday.
Okay.
Okay, so try to figure out who it is. I'm gonna reset your case for next Tuesday. That's the 16th, I believe.
It is, Your Honor.
Okay, so Mr. Kelly, if you don't hear from somebody, you may wish to see if he hasn't been paid, and you can't get in touch with him, you may want to speak with the public defender if no one has made an interim appearance on your behalf so that they can help you deal with these charges. But I'll give you till next Tuesday to raise your lawyer, okay? All right, so they'll see you back next Tuesday.
And Your Honor, just to let PD McLean know, I did put a recommendation in the chat while Ms. Abden was handling her probation revocation, so he may need to check courtroom to chat.
Okay. So I'm not sure if you heard that or not, but we'll let him know, Ms. Falk.
Thank you, Your Honor.
And yes, Mr. Gore's case is completed. There was a the Gregory Gore was completed. There's a waiver, and the case will be returned to the division judge, Ms. Gore. You're welcome.
Your Honor, I'm just waiting for the attorneys to finish interviewing the other clients.
Okay, just let me know when y'all are ready.
Yes, sir.
Your Honor, there was a waiver on position 8, Gregory Gore. I had hold for announcement, but I may have missed it.
Yeah, Mr. McLean made the announcement.
Okay, thank you, Your Honor.
What should I? Your Honor,
Yes.
what are we holding on for, Mr. Hightower?
Mr. McLean needs to speak with them. Apparently, Mr. McLean is speaking with someone else right now.
Okay.
So as soon as he becomes available, he'll give you all a call so that he can speak with him. Okay.
Okay, I will have to call him because I'm trying to do my first appearance interviews.
Okay. So that's however you all want to accomplish it. It's fine with me. So once he gets back, I'll let him know.
Thank you, Your Honor.
Okay.
Your Honor, whenever you're ready, we have position add-on, position number 3.
That was the other calendar.
This is going to be Mr. Sanchez Griffin.
Okay, add-on position 3.
That is correct.
Okay, and what are we doing with Mr. Griffin?
So Mr. Griffin has two cases. The recommendation was a global recommendation. The second case that's not on the calendar, it's 23 CR 004806F. That one is assigned to one of our attorneys. And so we asked for a reset so I can speak with her about possibly entering a plea. So it's my understanding that she's gonna get both of these cases set to, they already have a court date for this one. It's on the 22nd in the courtroom. So she's gonna set this case in the courtroom as well, so they can handle them together. But we are requesting to be heard on bond due to circumstances in his life that I just learned. So would you consider amending bond, although he does have court in 10 days?
Okay, so he's out on bond on the other case. He's and all right, so let me just start from the beginning then, because I don't know anything about this.
I can let the state speak to the fact, but yeah.
Okay, so I need to know what the present bond is and what the facts are, I guess.
$17,500 is my understanding.
That is correct. That was set by Judge Law on December 21st, 2023, 15,000 on the simple battery family violence and 2,500 on the criminal trespass. And let me just, and if pretrial could go ahead and put if you are there, if you would be kind enough to put the history on the record while I pull up the facts of the case.
Okay. Mr. Griffin, he has 6 arrest cycles beginning in 2010. He has 2 violations of probation. And it looks like, let's see, I'm not sure if this is the same case that is on the calendar, but it says his last arrest was August 4th of 2023, and it's a battery family violence also.
That is the second case.
The second case, okay.
Yes, and Your Honor, just to kind of put a little bit on the record, on that previous case, the 23 CR 004806F, the defendant did receive a $2,000 surety bond from Judge Law on August 5th of 2023. And then this case occurred, let's see, on September 2nd of 2023. And in that case, it involved the same victim. So I think the reason the Judge Law ordered her the somewhat higher bond on the second case is because on the first case involving Miss Belissa Jones, who's the victim, where the judge ordered August 5th, 2023 for a stay away and a no further contact. And then our case happened shortly after, within 4 months of that first case, where the defendant violated the conditions of the original bond order Judge Law had set and made contact and in fact did have violent contact with Miss Jones. In the second case, we have that the defendant on September 2nd of 2023, so that was literally within a month of the bond order in the first case, forced his way into the residence of Miss Jones, threatened her with a firearm, she stated she was in her room when she heard a loud banging on her back door. She then saw the defendant kick in her back door, yelling at her about money that her niece owed him, spit in her face, grabbed her TV, threw it outside, and then pulled out a firearm and waved it, saying he would kill her, her brother, and her son. Miss Jones stated that the defendant then left the location. There was clear damage that the officers observed to the back door of her residence, which was consistent with the door being opened forcefully while it was locked. Her TV was also clearly damaged. And that is in addition to the first incident, which was a month prior, which was for family violence battery, where it was alleged that in that case, the defendant at the same location, the officers were dispatched. She stated she was assaulted by the defendant over cheating allegations. He punched her in the back of the head. Her friend was able to call 911 and he fled the scene, and officers checked her out. She did have bruising to the back of her head as well as her shoulder. So I believe the recommendation by Judge Lal, and I can't, not making assumptions, was most likely based on the fact that he clearly violated her first order within a month of her making that order to stay away and have no further contact, and violated it with potentially a handgun involved. And so for those reasons, we ask that the bond remain as set.
And ASG Falk, in terms of discovery, all I have is the warrant affidavit. I don't see any mention of a firearm. I could be missing it. Could you please elaborate on that?
That was in the police report. So it was not in the initial warrant affidavit, but it is in the police report. It literally says, the first line is on September 2nd, 2023, Officer DeSantis responded to a dispute involving a weapon at 1890 Myrtle Drive Southwest 205. And so obviously we're going to have to do some more digging into this case because again, there was allegations that a firearm was employed. The only thing I can take a guess at is because there was no secondary witness to that is potentially why a warrant for any kind of firearm charge may not have been taken out. So that's the only thing I can, and I'm presupposing, but I'm not sure why it wasn't taken out. But the warrant does clearly state that that the victim did state there was a firearm involved.
Thank you. So obviously, we do need to dig into this a little bit more on our end as well. That's why I spoke with PD Rose Woodbury is who it is, and she is planning on putting both of these cases, like I said, on the calendar the 22nd. Normally, I understand that we would just wait until that's handled. However, there are some circumstances in his life that he would like to be out on bond. Specifically, he found out 2 days ago that his grandmother had passed. And so he wants to be able to attend the funeral. I understand the allegations are concerning. I understand that, this likely should be handled at a later date. But given the circumstances and additional information I've gathered on bond, if Your Honor would allow me to be heard on that, I would like to propose that he be let out on a signature bond through pretrial. Any and all restrictions the court deems necessary, primarily for the purpose of going to his grandma's funeral. He'll be back in court in 10 days. We have contact information for him, may I be heard on bond? Should I continue?
Yes, that's what
Thank you.
I'm here. Do you have a certificate of death for me?
He just told me this morning. I'm happy to, I have his mother's number. I can call her real quick from the courtroom, see maybe she can send it over, but he told him over the phone because he's planning on staying with her once he's released. And so they were arranging for that if bond was reduced or he was given a signature bond, and that's how he found out.
Okay.
And Your Honor, given the violation of the first bond order on his initial case, we would actually ask that his initial bond be revoked for violating.
And was that bond a signature bond through the jail?
It was a $2,000 surety bond. At that first case was a $2,000 surety bond with a stay away and a no further contact provision.
Sorry, we have a lot going on. Okay, so on bond, he is 31 years old. He's lived in Georgia his whole life. He would be staying at his mom's house. It's in Forest Park. And I do have the address. His mom is elderly. She has diabetes and she can't see. So he's the primary caretaker. He's planning on staying with her. This is not the address where Ms. Jones lives at. So he would be far away from her, does not have contact with her. It is also my understanding they've had no contact whatsoever since the alleged second incident at all. So the complaining witness is his ex-girlfriend. It's my understanding that the alleged victim was under the influence during both incidences. And again, we will address this in the courtroom in more detail, but for now, he tells me that it was a misunderstanding and he actually was the one who called the police. He does deny the allegations as stated. And so, but you know, we'll deal with that another time. He also has an 11-year-old daughter, not with the complaining witness. She lives up the street from the address where he will be staying with his mom. So that would allow him to see her more often. And he's responsible financially. He's also very involved. And so if he is let out, he'll be able to do that. As he's been in jail for some time, he did lose his job. And he plans on trying to get another job in the meantime. And so I understand the allegations are concerning, and I understand, you know, this will be dealt with in 10 days, but I am asking Your Honor to consider allowing him to just go to his grandma's funeral and then come back in 10 days and deal with this in the courtroom.
Do we even know when the funeral is at this point in time?
I know it's sometime this week, I don't really know at this time.
You don't know exactly when?
No, it's sometime this week though.
He said it's sometime this week. If you would like, I can just give his mom a call. I just found out about this morning, Judge. I apologize.
Well, without some confirmation as far as a death certificate or that or anything of that nature, I'm not inclined to change the bond situation. If you want, we don't. If there is some confirmation, then I might I won't be able to consider it. But if you want to, and I don't know if next Tuesday would be too late or not, since we don't know. If you want to make that argument next Tuesday, I'm happy to give you the opportunity to get more information and make that before whomever's here.
Is there a way that we can, do we have other cases, ours? Would it be possible for us to just hold until the remaining clients go, and then I can try to call his mom maybe in the meantime?
Okay, that's fine with me.
Thank you.
Okay, so we can come back to Mr. Griffin.
Thank you.
Two announcements, Your Honor.
Okay.
Mr. Gore has been watching court and has been thinking and would like to accept the plea. We disposed of him earlier with a waiver of presence and arraignment. He says he would like to accept the state's offer. Gregory Gore.
Okay.
Likewise, Your Honor, Mr. Hightower, I've consulted with on the phone. In addition to the visit last night, we talked about the specifics of the plea offer today, and he would like to make a negotiated plea as well.
Okay. So who do you want to start with?
Either one. I mean, one's on Zoom and one's here.
Okay. AC/DC wants to start there, I believe, and tell me what position this is and the name again, please.
Mr. Hightower, so being an H, it's number 11 and number 10, 10 and 11, 10 and 11.
Okay. Good morning again, Mr. Hightower. I'm Judge Eric Morrow. This is the state court expedited. This is a state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Hightower.
He's the offender, I'm the offender.
Okay. Shannon, whoever's on Shannon, good, thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation on this case is 12 months served 120 days, credit for time served 22 days. That's going to be from August 21st to August 26th of 2022 and December 27th of 2023 to today. We're also recommending Family Violence Intervention Program, 40 hours community service, no further contact with Shantana Hightower, stay away from 294 Browley Road. The state will put on the record that the defendant had a previous family violence battery conviction, which is why we made this recommendation. It did not involve the same victim, which is the reason why we were trying to get that information from Clayton County. The state would ask the defense to stipulate to venue, factual basis, and identification, and we would like to sound for Miss Shantana Hightower.
We do so stipulate.
I released Ms. Hightower earlier, given that there was a waiver that was going to be filed and that was announced, so I know that she was with us.
I'm sorry, Your Honor, that waiver was Gore. We're talking about.
Right.
Gore was.
Okay. I'm sorry. If Ms. Shantana Hightower is with us and wishes to address the court, now's your opportunity to do so. Okay, doesn't appear so. Yes, Mr. McLean.
Your Honor, he asked the court to accept his negotiated plea.
Mr. Hightower, it's my understanding that in case 22 CR 003059E, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Hightower.
Thank you.
Your Honor, I'll note for probation purposes, I do have contact information, and since it will a few extra days of jail, I will mail to him the information on JCS's address or drop it by the jail.
Okay. And who do we have next?
Gore would be number 89.
I'm sorry, Judge, could I interrupt very briefly and just ask to be put in a breakout room with Miss Shannon Ijaoba? She's the mother of my client. He's a minor, and we'd like to speak very quickly.
Okay, that's fine. Miss Shannon, are you with me? Shannon Ijoba, Mr. Ijoba, can you hear me?
You did just
I can hear you, but I can't see you.
Okay, well, we can't see you either. Oh,
There we
you are.
go.
Okay, so I'm gonna place you into a breakout room with counsel, okay? So
Okay.
Miss Champion, just let me know when you're ready to. So Miss Champion's doing double duty today, so I'll let her go ahead and place him into a breakout room before we move forward.
Okay.
Oh, I know. So I have no.
Now, we're gonna go
Put
back
them in
to,
the breakout room, Judge.
They're in there now?
Yes.
Okay, thank you, Miss Champion. Okay, we're gonna go where now?
back to 89, position 89, Mr. Gregory Gore.
Okay, good morning, Mr. Gore. I'm Judge Eric Morrow. This is the state court expedite, the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Will you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can place your hand down. Ms. Falk.
Yes, Your Honor. The state's recommendation on this is 12 months probation, serve 66 days, credit for time served 33 days. Those 33 days ran from January 19th to February 1st of 2023, and then December 24th to 2023 to today. The balance will be probated, excuse me, Family Violence Intervention Program, 40 hours of community service, no contact with Latonia Green. And we're also asking for stay away from 3599 Martin Luther King Jr. Drive. That's a Planet Fitness, as well as no firearms. The state would ask the defense to stipulate to factual basis, venue, and identification. And as Your Honor aptly stated, Ms. Green was present, but did leave the Zoom because we believe this was going to be a waiver.
Thank you, Ms. Falk. Yes, Mr. McLean.
Yes, Your Honor, he does stipulate to the three elements named by the state and ask the court to accept his plea.
Mr. Gore, it's my understanding that in case 23 CR 0000354H, you wish to plead guilty to battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation? You have to speak up for me, Mr. Gore.
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Yeah, I'll accept the plea as negotiated, Mr. Gore. Good luck to you, sir.
Thank you.
Oh, if I might ask Ms. Falk, did y'all have a notion from Ms. Green prior to her leaving? I mean, we have to live with the timing of things because we made the decision when we did. But did you have a notion of whether there was no further violent contact she wanted?
I did not. We had reached out to her by email to notify her of today's court date. Let me just double check one thing. I'm looking at my victim's notes, but let me just look in the system as well and see if there was any previous notes before this last attempt at contact. But no, as to my knowledge, we were not able to successfully get information from her regarding whether she wanted further contact.
I'll just have, if the ruling of the court in the sentence is no contact, I'll just have to advise him that if he wants to change that, he'll have to bring a petition to the court.
Okay, so advised.
Okay, Your Honor, and just to let Your Honor know, in January 10th of 2024, so we did have recent contact. She did state she wants contact with her husband and for him to be home. However, I just want to point out to the court that there was also a second case involving these two, which was 22 CR 004364A. So there was previous instances involving violence here, which gives the state concern, and I believe is what led to our recommendation of no further contact. That was a family violence battery that was null prost in February of 2023. And then this incident happened on, let me just get the date again. This incident then happened on this incident happened November 2022. So it preceded the null pros, but was after the first incident, if that makes sense.
Okay. So the recommendation was no contact.
That is correct.
Given that we have not heard from the victim in the matter, it will remain no contact unless it's modified at a later date.
Thank you, Your Honor.
Understood.
All right. Good luck to you, Mr. Gore.
Thank you.
I haven't received she's a counter offer, so she's gonna think about it. Shelley has not answered it yet. Ms. Falk.
Mr. McLean, I didn't see your message. I just saw it. Do you want me to give you a call?
She wants to know if you want her to give you a call.
Yes, on 2392.
2392. All right, will do.
Thank you.
Your Honor, it's just a waiting game right now.
Okay, you all let me know when you're ready.
Yes, Your Honor.
But I mean, the session's unlocked, it's like. Yeah, I'll see Judge.
You ready?
We're ready.
Okay, and who are we ready on?
Mr. Joyner.
Okay, and so Mr. Joyner, is this the same, is he on, he's on the all-purpose calendar and the probation revocation calendar?
Correct.
And what are we doing with Mr. Joyner today?
A non-negotiated plea, Your Honor.
Okay. Let's see. Good morning, Mr. Joyner. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, I do. Good morning.
Thank you. Good morning, sir. Can you raise your right hand? Do you swear affirm the testimony you're about to give before this court be the proof, the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. You can place your hand down. Ms. Tyson, may I get the history, please?
Yes, Your Honor, it looks like Mr. Joyner, he has 7 arrest cycles beginning in 2016. Looks like he has 1 violation of probation from 2023. Doesn't look like he has any felony convictions. Let's see, one moment.
In your honor, we may have a tiny issue. So we apparently, one of his cases was left off the calendar. I'm seeing 4 cases in case manager, but only 3 cases on the calendar, unless I missed something.
No, thank you, because I was looking, I saw all of them listed on GCIC. But, and I was trying to figure out one of the cases was just, if it was 2 arrests for the same case, didn't know. But
Yeah.
okay. That
So
helps, thank you.
Yeah, not a problem. He had a criminal trespass in March of 2023 that I think it was left off of the calendar. It's 23 CR 003596Y. In talking to the clerk's office, I will say, so that they can get the proper file and we can move forward on this, the state's recommendation and the defense's request all still would have involved more jail time. And so I'm not sure if Your Honor wants to reset this, come back and try to pick up the last one next week. I don't know how you'd prefer to handle this.
I prefer to handle it more efficient.
I'm sorry, Your Honor, we couldn't hear you.
I prefer to handle it all at one time. I believe that's more efficient, given that there's a request for more jail time and there will be more jail time. Would anybody have an objection to resetting it until next Tuesday?
Your Honor, he does, he's ready today. He understands about criminal trespass and we're gonna go with the court's direction.
Thank you.
But he's ready to leave it open because it is minor, it's a minor thing compared to these domestic violence cases.
You ready?
Okay, well,
You can go either way.
he's gonna have to come back regardless, so why not do it all at one time?
That's
Right.
the perks. Unless the state would love to just drop that CT.
Okay, Your Honor, let me look at the criminal trespass while Mr. Graham addresses the remainder of his cases, and let me see if I can shoot out an offer.
Okay,
Okay.
thank you. Yes, Mr. Graham.
All right, thank you, Your Honor. So, just for my own clarification, I've got a simple battery, family violence, 2 simple battery, family violence cases, and then 1 battery and cruelty to children.
I have position 14, the 2 batteries and a cruelty to children is what I have on the calendar. Is that right?
Okay, yes, thank you, Your Honor. My apologies.
Okay. No fun. Okay, so you just want to start with position 12 or whoever you want to start, Mr. Graham.
All right. Okay, I'll start with position 12, if that pleases the court. This incident took place on September 17th of 2023. Law enforcement responded to a domestic dispute at 3909 Campbellton Road Southwest, apartment F12, Atlanta. Upon arrival, The officer spoke with the victim, Miss Tabitha Henderson, first name spelling Tabatha, who advised that she and her boyfriend, Mr. Joyner, had an argument, during which he grabbed her by the neck and pushed her. Additionally, she advised that Mr. Joyner threatened to throw her out of the second-story window. All of this occurred in the presence of Miss Henderson's 3 children, ages 10 and 5. At the time of the officer's arrival, Mr. Joyner had locked Miss Henderson out of the apartment with the children. He left in Miss Henderson's car and took the keys. Miss Henderson made phone contact with Mr. Joyner to have him return the keys. During this phone call, the officer heard Mr. Joyner admit to the physical contact with Miss Henderson. The officer also spoke with him in an attempt to persuade him to return to the location, which he refused. He ultimately left the car with the keys inside at a gas station nearby. The officer went to the gas station to retrieve the keys. The car was retrieved by Miss Henderson's oldest daughter, who no longer lives with Miss Henderson. And this is a global recommendation with the position number 13 simple battery case. And that incident was just a month before, August 14th, 2023. Took place at the Texaco gas station at 3749 Campbellton Road and back of the apartment. At that time, law enforcement responded. Upon arrival, Ms. Henderson advised that she and her boyfriend had an argument early in the day, that he walked to the gas station to de-escalate the situation, that he followed her to the gas station in her car, began slapping her repeatedly once inside. She told the officer that he had been drinking and that he drove off in the car. The officer reviewed the footage at the gas station, observed no visible injury to Ms. Henderson. The state is recommending 12-month probation consecutive to, I apologize, Your Honor. This is a global recommendation also with position 14. 2 counts of battery and 1 count cruelty to children in the 3rd degree. On that incident, on December 26th, 2023, law enforcement responded to 3050 Mount Gilead Road Southwest, Atlanta. He spoke with Miss Joanna Lowe. She advised the officer that her brother, Mr. Joyner, became upset when some women he had over at the house were stopped by the Atlanta Police Department after they left. He thought that she had called the police on them. Miss Lowe stated that he said, "I'm gonna teach you bitches today," started hitting her on the stairs. He then pushed her into the room, started punching her in the face. Once in the room, Mr. Joyner also saw Miss Kenya, Canya Mitchell, who was on the phone and doing her hair. He grabbed the phone off the dresser and pulled out some of her hair. Miss Mitchell saw Mr. Joyner continue to punch Miss Lowe in the face, so she ran downstairs to get a knife from the kitchen. Miss Lowe stated that she was hitting Mr. Joyner to push him off of her. Miss Mitchell started poking him with a knife in an attempt to get him off of her. At the time, Mr. Joyner threw a Bluetooth speaker at Miss Mitchell, striking her in the face, then started punching her. Miss Lowe stated the fight ended with one of her friends who had left before the police arrived, broke it up, forced Mr. Joyner out of the house. Both of her children were in the room when he was hitting both her and Miss Mitchell. The officer observed that Miss Lowe's eyes were bruised and swollen. She had a bloody nose. She refused medical care. Miss Mitchell had bruising on both cheeks, was bleeding from her left index finger and her nose. She was transported to Grady Hospital for medical care. The state is recommending on count 1, battery, 12 months jail, credit for time served 15 days. That was beginning from December 28th. On count 2, battery, 12 months, probation consecutive with count 1, FVIP, 40 hours community service, no further contact with Joanna Lowe and Kenya Mitchell. Stay away from 3050 Mount Gilead Road Southwest. No further contact with Tabitha Henderson. Stay away from 3909 Campbellton Road Southwest. On count 3, cruelty in the 12-month probation concurrent with count 2. And on the simple battery cases, the recommendation is 12-month probation consecutive to position 14. So for a total total recommendation of 36 months, served 12 months, credit for time served 15 days, starting December 28th, 2023. Balance probated, FVIP, 40 hours community service, no further contact. My apologies, Your Honor. I'm just trying to keep them all together here. No further contact with Joanna Lowe and Ia Jackson. We're also asking for ADET and restitution open for 30 days.
And Your Honor, I was able to look into that criminal trespass, and that was the recommendation that Mr. Graham just gave on that last case. So the criminal trespass was case number 23 CR 003596Y. And it occurred on March 5th, 2023 at 5401 Old National Highway. The defendant was in a dispute with his mother, Miss Kawana Jackson, and she stated that in a drunk rage, he damaged her 55-inch Sony television and broke figurine statues in her room by punching and throwing the items. She said he became upset when he got drunk and she confronted him about his behavior. He punched out a car window in the parking lot, cutting his arm. And so that was the recommendation, the last recommendation that Mr. Graham gave, which was the 12 months concurrent with 23 CR 008449Y. No further violent contact with Kawana Jackson, ADET, and restitution to remain open for 30 days. I did attempt to get in contact with Miss Jackson, and there have been previous attempts to get in contact with her, but she has not returned. She did not answer the phone when I called.
So just so that I am clear, on positions 12, 13, and 14, those are all going to run consecutive, or you're asking that those run consecutive for a total of 36 months with the criminal trespass running concurrent. So it'll be a total of 36 months, 12 months to serve, credit for time served 15 days. And with the rest of the recommendation that is listed. Did I miss anything?
I think that of what was consecutive, it was going to total 24. Am I mistaken? Because I thought two of the consecutives were consecutive to the same thing.
No, it is 36.
It is
the
36.
ultimate recommendation.
All right.
And just so we don't miss this aspect, we would like to sound for Miss Joanna Lowe, Kenya Mitchell, Tabitha Henderson, and Kawana Jackson, who are all of the victims on the cases.
So I see Ms. Henderson here. Ms. Henderson, if you would like to address the court, now is your opportunity to do so. You, of course, don't have to address the court, but if you would like to, now would be your opportunity.
I'm here, Judge.
Okay, would you like to address the court, Ms. Henderson?
Yes.
Okay, can you raise your right hand for me? Do you swear, okay, do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court?
As for the no contact order, like I said, we talked it out. I told him that he had to go to the drug classes. He had to find some drug classes and, you know, stay off of the alcohol or whatever. But other than that, when he's not drinking, he's gentle, he's perfectly fine. Like, my kids adore him. It's just the drinking has to stop. If the drinking stops, he's not a problem to anybody or anything.
Okay, anything further?
No, that's it.
All right, thank you. We appreciate you being here today, Ms. Henderson.
You're welcome.
Okay, let's see, Mr. McLean.
Your Honor, even before we heard about the state's recommendation on the criminal trespass, we were going to suggest ADET. So the state took the words right out of our mouth. The ADET would be completely appropriate in this situation. The only difference he's asking for, he's taking responsibility for a lot of stuff here. And he understands why he's taking responsibility for a lot of stuff. He understands why. He understands the purpose of the punishment. Part of the purpose of punishment when there's a stretch of incarceration is reflection. Part of it is a little suffering too. But in the reflection part, we would like to emphasize that if the court were to see its way clear to believing that society's needs would be served by 180 days in place of the 12 months recommendation on the jail portion, then he would, with good behavior in jail, he would do approximately 90 days minus whatever credit, instead of approximately 103 days minus whatever credit. So that's the only difference, Your Honor. He was going to add in there that he knows that alcohol is not, that's one of the problems. So he was going to suggest that in addition to him asking for 90 asking for 6 months, 180, instead of the 12 months on the jail portion, that he go up and ask the court to give him ADET as part of it, that he go up and ask the court to consider whether anger management would also be appropriate. And he certainly understands the burden and the benefit of the extremely long-term FVIP.
Okay, before I make a decision, let me hear, given that he's on the probation calendar also, let me hear from Officer Allison. Yeah, so what's been going on with him on his probation case?
So Mr. Joyner, he owes probation fines and supervision fees of $1,050.50, probation supervision fees of $400, victim crime funds of $90, failed to report as directed on April 24th, 2023, May 4th, 2023, May 11th, 2023, and May 30th, 2023, failed to submit to a drug and alcohol evaluation, failed to provide proper samples of court-ordered drug and alcohol testing, did not complete risk reduction course, and did not complete victim impact panel. He does have 485 days remaining on this case. We are recommended to continue on probation and complete the ADET within 30 days.
Well, there was going to be ADET anyway, Your Honor.
Okay, and let's see, in regards to this, is this your case, Ms. Vigiletti?
Yes, Judge. I just,
Okay.
Mr. Joyner, he understands he did fall off of probation requirements. There was an issue with mail going to his grandmother and having some instability, but he has updated me with current contact information. We reviewed the requirements of his probation. He understands the requirements in the Officer Allison's recommendation, and he's happy to get back on probation and get this done.
So I wanted to hear from probation first because that case goes back to 2019. Had he done the drug evaluation and treatment, had he been given samples, had he been doing all that, he might not have gotten himself into the situation that he ultimately got himself in with all of these other charges. So he didn't go to probation the first time, didn't report, didn't do anything that he was supposed to do. And you're asking for some leniency on his behalf. Had he done anything, then that request might not fall on deaf ears. But because he did not do anything, as far as the cases go, I'm going to accept the state's recommendation if he wants to plead. I believe that I will require the 12 months in of incarceration. As far as the probation case goes, I will reinstate him to give him the opportunity to do what he's supposed to do. Ms. Vigiletti, I will reinstate him on the probation cases. If he wants to move forward, Mr. McLean, with a plea, it will be with the recommendation accepted of the state.
Understood, Your Honor. Today is responsibility taking day for Mr. Joyner, and he's not withdrawing his plea. He can live with the 12.
Okay, so Officer Allison, I will reinstate him. And he is, given that he'll be incarcerated, he's to begin reporting within a month of getting out of incarceration. Or how often? I would like him to do it before then, though, within 2 weeks.
Can we do?
Go ahead.
I was gonna say, can we do within 48 hours upon his release?
Okay, that's fine. 48 hours upon release.
So, Your Honor.
And would you be accepting to complete the ADET within 30 days? Or they'll be upon his release.
Right. Let's give him 60 days.
Okay.
Okay. Okay.
And Your Honor, could it be no further violent contact with Ms. Henderson?
No, it can't be. No further contact. He can seek a modification at some point, maybe later on, but at this point in time, until he starts getting himself under control with his alcohol and drugs, then I'm not going to allow him around those children, and I'm not going to allow him around her.
Understood.
Okay, but once he proves himself that he's actually doing something, then he can seek a modification at a later time.
Yes.
Okay.
Your Honor, excuse me, Your Honor, in purposes of the plea, we would ask that the defense stipulate to factual basis of any identification.
For case number 12, 13, 14, the add-on criminal trespass, we do so stipulate in each of those cases for the purposes of these pleas.
Okay. Anything further before I take the pleas?
Nothing.
Okay. Mr. Joyner, it's my understanding that in case 23 CR 0084447Y, you wish to plead guilty to simple battery family violence. In case 23 CR 0084448Y, you wish to plead guilty to simple battery family violence. In case 23 CR 0084449Y, you wish to plead guilty to 2 counts of battery and 1 count of cruelty to children in the 3rd degree. And in case 23 CR 003596Y, you wish to plead guilty to criminal trespass. Is that correct? Is that a yes?
Yes.
And are you under the influence of any drugs or alcohol this morning?
No.
You can be represented by counsel. Are you satisfied with your counsel's representation? You have to speak up for me, sir.
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Yeah, I will accept the plea with the terms of the global resolution will be 36 months to serve 12 months, credit for time served 15 days, balance probated, a family violence intervention program, 40 hours of community service, no further contact with Tabitha Henderson, stay away from the Campbellton Road address, no further contact with Joanna Lowe and Kaya Mitchell, stay away from the Mount Gilead address, ADET, restitution, which will stay open for 30 days, no drugs, alcohol, weapons while on probation. Let's see, did I get everything, Mr. Graham?
Yes, sir. Yes, sir.
Okay. All right, Mr. Joyner, good luck to you, sir.
Oh, and Your Honor, I did notice in reviewing all the paperwork again, I did see the 36 month. Apologies for the error.
No, you're fine. Thank you.
Your Honor, that concludes probation matters. Can I be excused?
Yes, give me 1 second now. And I received a second calendar. Did we complete the second?
I think it was just an updated one because we had the add-on person, which was Mr. Hall.
Oh, okay. So we've covered everything? Okay.
Yes.
Thank you. I'm sorry. I saw that I had two calendars and I wasn't sure. Okay. Thank you, Officer Allison. Once you get me the paperwork, I'll get it signed.
No problem. Thank you. Have a good
All right.
one. Can
You do the
PD
same.
just
Thank
make sure they email me the petitions, please?
Yes, ma'am.
Okay, thank you. Have a good one.
Okay. Who do we have next?
Judge, if we could move to position 21, Jaden Smith.
Okay.
I'd like to request that we reset this case for January 23rd. I just wanted to provide the court the reason for that. Mr. Smith is a minor, and this incident involved his mother, and the state's recommendation involves moving out of his home. So there's just a lot of questions because they don't have a support system in Georgia. Where will he live as a minor? There's some MH and medication that needs to be addressed. The social worker is aware and is working on coming up with a plan for that. So there's a lot of open questions, and we're hoping by January 23rd, there will be a plan along with Kasha, our social worker, for how he can be successful going forward. But we're not prepared today.
Okay, that's fine with me. We'll reset that position 21, Jaden Smith, until the 23rd of January.
Thank you.
Okay. Let's see. On the add-on calendar, what are we doing with position 6? Well, it's Gregory Vaughn. Did we take care of Mr. Vaughn's cases?
I apologize. That's Mr. McLean.
Your Honor, that was the case. Position 6 was the one where the bond reduction request was denied. It was reset to the original courtroom. And then position 22 was the associated case on the regular calendar where Your Honor reduced the bond to $1,250 surety bond.
Okay, thank you.
Not a problem, Your Honor.
So have we taken care of everybody on the state all-purpose calendars?
I think we need to circle back to Gore. That was the only one that I'm aware of that we did not get a final decision on.
I think we need to do add-on 1 of Zachary Alexis. I didn't have anything on him. And what's going on with the add-on 3 Sanchez Griffin?
On position 1, Alexis, my understanding was that there had been a request from the PD's office to have that case reset to January 25th, SAP for a social worker visit. And I don't know if there's still their announcement this morning.
I apologize, Judge. None of these are my clients, so I have the same information as Ms. Falk.
Okay.
And I know that Sanchez Griffin was reset to January 22nd. Actually, Sanchez Griffin, it wasn't Gore. My apologies, Your Honor. It was Sanchez Griffin that we needed to address because that's the one where he said his grandmother had died and we were waiting for proof.
Right. And is Mr. McLean, is he
He's speaking with a client.
okay, and Miss Abden, that was Miss Abden's case.
What's that?
Are you Sanchez Griffin?
No, I think that's Miss Abden's case, Sanchez Griffin, if I'm not mistaken.
Ms. Abden stepped outside quickly, but perhaps we could do Mr. Burton and circle back to Sanchez Griffin when she returns.
Burton's a DVBW.
Okay.
Burton is the DVBW case.
Yes, Judge, and Gilbert Sperling III is here on behalf of Mr. Burton. I got retained yesterday and I filed entry, but it hasn't been served yet.
Welcome aboard. Thank you.
Okay.
Mark, I don't have anybody more.
Okay, so where is Mr. Burton?
Ms. Burton is
case?
over Zoom.
I'm
She
here.
has like a.
Okay,
I'm on.
all right. Very
Hello, how
good.
you doing, sir?
Yes, Mr. Burton. So I heard Mr. Burton on Tuesday and I reset that. This is the case that I reset from Tuesday. Is that right?
Yes, sir.
Because we had some concerns regarding something that was on the jail screen. Have we figured that out, Ms. Falk?
Your Honor, that is the one, hold on, and let me just double check. Okay, so I'm reading the note right now. So apparently, this was a cash bond only warrant. And so normally those are not placed on the calendar because there is a requirement of a cash bond as opposed to a surety or a signature bond. And it was, so the case was added to this calendar on the 4th, but then the warrant was issued on the 5th by Judge Morrison, who did issue a cash bond warrant. So this case actually was accidentally added to the calendar. It should have been addressed by Judge Morrison due to the cash bond.
Okay, so it should be returned to Judge Morrison to
That is correct.
determination.
Okay, call the roll.
Okay, so Mr. Sperling, you need to get on Judge Morrison's calendar for this, okay?
Understood.
Can I ask you something?
Mr. Burton, you have a right to remain silent. Anything you say can be used against you. You should speak with maybe Mr. Sperling in private so that you don't, we're live over YouTube and anything that you say can be used against you. So speak with him privately after our session, okay?
Yes, sir.
Yeah.
All right. Good luck to you all. We appreciate you
All right,
being
thank you,
here.
Honor.
Okay.
Pick up the phone.
Let's see, is there anyone, have we? I have a lot of calendars. Have we gotten everybody from the SAP calendar?
We have completed my section of SAP, Ms. Bigelow. Have we completed all your cases on SAP or probation?
We have Ms. Abden's one client, I believe, that she's trying to get some information on.
She's back.
And Mr. Burton, you're free to go, Mr. Burton.
All right, thank you.
Okay, you can.
Your Honor, we're gonna go back to Mr. Sanchez Griffin.
Okay,
So I spoke with Rose Woodbury. She said that we should just go ahead and reset it to the reset it for the notice. She'll get it on the calendar on the 22nd. And I would. We weren't able to get a copy of the certificate. Obviously, it's not enough time. And so if Your Honor would be willing to at least consider reducing the bond a bit, it is very high. There is no way that he can make it now, and I don't believe he'll be able to make it, but maybe he'll give his family the opportunity to try to, and possibly get him, to the funeral. And we're going to be working with his mom to sort this out for him in the meantime.
okay. It's my understanding that the current bond is 17,500 on total, what was it, 15,000 on the simple battery and 2,500 on the other one?
Yes, Your Honor, and the state would object to any reduction of that bond. He's already violated the bond conditions of his previous bond within a month of it being ordered. There's not an IALA factor at this point, with the exception of failure to appear, that he is actually complying with. He is risk of reoffense. He's already reoffended. We have danger to the victim. It's alleged he waved a gun in her face after kicking in her door. And I understand that these are allegations. The problem is it still adds up to a dangerous situation for our victim.
And ASU Falk, have you confirmed this with the complaining witness?
Let me see if we have reached out to her. I will say that this was confirmed in the police report that the complaining witness gave to the police. But let me just reach out to her and let me just look in our notes as well.
Because I did speak with PD Woodbury, and she did say that she spoke with the complainant who did not wish to prosecute, but again, you know, if you're able to confirm that. They're not ready to fall.
I'm looking at our newest case. We did have contacts. Wait, nope, we did not have contact. But when we were doing our prep is when we found that he had a previous case with her from a month prior. And I would, Your Honor, the state would also just make it clear for the record for both PD Abden and PD Woodbury. And if you could be so kind, PD Abden, to communicate this to PD Woodbury, we are withdrawing our recommendations as to both cases.
Will do. And Judge, I understand, you know, the allegations are concerning. However, the bond is extremely high, and that he's just really trying to make it so he can go to his grandma's funeral. His indigency is concerned. He does have a minor child. He will be, if he does get out, he will be with his mother, who is also disabled. She's blind. He takes care of her. And so if Your Honor would just consider reducing it, that would make a difference.
Given that he has another court date, the best that I can do, Ms. Abden, is that I can allow you to come back on the SAP calendar next Tuesday if his grandmother has not her ceremony has not been by then, and if you'll have some other information, then I'm sure that whomever is the judge would consider that. But as far as today goes, I'm going to leave everything as it is. Okay, but if you would like additional time until next Tuesday, I encourage you to reach out to see if you can get information regarding that. All right. Good luck to you, sir. Okay, so I think that concludes the 9 o'clock calendar. Would we like to go over the calendar before we do the competency calendar, or how would you all like to do that?
Yes, Judge, because I'm the only one on that. They're probably going to leave, so.
Okay.
Thank you.
All right. So if we can go over when you're ready, Mr.
Yes.
Position number 1 is reset further notice. Position number 2 was a plea. Position number 3 was non-pros. Position 4 and 5, reset further notice, defendant released. Position 6 and 7 was a plea. Position 8 was a plea. Position 9 was a non-pros. Position 10 was a plea. 11 was a non-pros. Position 12, 13, 14 were all pleas, and he also had an add-on case, which was a plea. Position 15 is going to be reset to the SAP 116 for the private counsel to appear. Position 16 was a plea. Position 17 was a plea. Position 18 was a non-pros. Position 19 is reset to the SAP 118. Position 20 was a plea. Position 21 is reset SAP 123 for a social worker visit. Position 22 reset further notice with an amended bond of $1,250 good bond. Position 24 was a plea. I'm sorry, 23 was a plea. Add-on 1 was reset SAP 125. Add-on 2 reset further notice with the amended bond to $1,000 pretrial level 1. Position number 3 is reset SAP 116 for additional information. Position number 4 reset further notice. Position add-on 5 reset further notice. Position add-on 6 reset further notice. Any questions?
Okay.
And can you please make sure you send the plea paperwork to April Champion instead of Miss Grace. She's out.
I apologize, Judge. I don't have the add-on calendar in front of me, but Jasmine Matthews was on the add-on calendar and she pleaded not guilty. I'm missing, I'm sorry, I don't have it, but what?
Yes, I did state reset for the notice, not guilty.
Oh, I see. Okay, thank you.
Okay, anything else on the morning calendar? If not, I guess we'll go into the breakout room for the competency calendar.
Yeah.
So
Who all needs to be in the breakout room, Your Honor? I'm sorry.
I believe Mr. Murphy, Ms. Abdon, Ms. Falk, you, me. Anybody else and anybody else on?
No, I need you to talk.
Your Honor, Miss Cheney can also join the breakout. It's under SG Victim Advocate.
Okay.
Yeah.
we've completed the calendar. Thank you all. I'll see you. I'll see you next time. You all have a good day.
Thank you.
Thank you, Your Honor.